All right. Good afternoon, ladies and gentlemen. Thank you very much for joining us for our June webinar. Just by way of introduction, joining me today is my colleague Karine Coetzee, joining us from Cape Town. Karine is Trafalgar's National Community Scheme Manager, over 20 years experience in the industry. And joining us tonight for the first time is Brendan Beach, my colleague who works alongside me in our Johannesburg office. Brendan is an attorney by training, a senior portfolio manager with many years' experience, and recently launched an advisory service related to CSOS matters and other topics which he will mention. Tonight, we are hoping to present what I think is a very important topic in terms of CSOS, the Community Scheme Ombud Service. Most of you will know that community schemes are required to register and pay levies to CSOS. So we thought it would be a very good idea just to cover in very practical terms, number one, how to be fully compliant in terms of CSOS legislation and requirements. And then number two, in particular, how to use CSOS effectively in terms of conduct rule registrations and in particular their dispute resolution channel. Unfortunately, as managing agents and owners as well, we see lots of disputes arising in community schemes with people living at close quarters alongside each other with different habits, values, cultures, etc. And CSOS is a very important and a very useful channel to, decisively adjudicate disputes, provide binding orders, and really achieve an outcome in a reasonable amount of time at low cost to be able to move forward and to avoid just endless repetition, endless escalation, and growing frustration. So tonight we would like to very much talk through the practicalities, the recommendations, and ways to use CSOS in an effective way for that purpose. I'm going to hand over to Karine shortly just to take us through initially the legislation in terms of CSOS, just to give us an overview of what's there, what it prescribes, and then Brendan will take us forward from there in terms of the practicalities that I mentioned. We'll finish by 6 as usual. Karine and I will answer any questions that you would like to have answered in the Q&A. We will be circulating a link to all those who registered for a recording of this webinar. As usual, it will get loaded on our training website, which is training.trafalgar.co.za. All our prior webinar recordings are there. They are YouTube links. All our training material is freely available. We try and provide as much useful content about community schemes, particularly targeted at trustees and directors to help them perform their roles as effectively as possible. There will be contact details at the end of the presentation. You're very welcome to contact Karine, Brendan, or myself for any feedback afterwards, any questions that weren't answered. We'll gladly get back to you as soon as we can, which is typically on a same-day basis. And it's our role to provide support, to answer questions, and to give advice based on our practical experience. So thank you once again for joining us. There will be a short survey that pops up when you leave the webinar. If you have a moment, we would appreciate your feedback about how you experienced the webinar, any suggestions for improvement, and in particular, any topics you would like us to cover on our further monthly webinars. All right, Karine, if I could hand over to you to carry on. Thank you.
Thanks, Andrew. Just to add to that, there's no need to ask in the Q&A for the slides. The email after the webinar that I will be sending out tomorrow to everybody who registered, as Andrew said, will include the slides as well. So just wanted to add that. Okay, so first up, let's look at CSOS registrations. So the CSOS Act, which I will also be sending with that email after the webinar, basically states that all community schemes must file a registration form within 30 days of the scheme coming into effect, or the date of incorporation, or the scheme or the coming into effect of this regulation. This regulation has been with us since 2016, so there's no more excuses. The only questions I regularly get is, what is a community scheme? Who must register? So if you look at the definition, which I'm not going to read through, which is there on the slide, you will see that basically it incorporates all property developments, all schemes, all body corporate, homeowners association, retirement village, all of those. I had a question recently where they said, but we are an industrial body corporate. We are not a residential body corporate. So why do we have to register? So as you can see, nowhere in this definition does it say that this property development or this scheme must be a residential scheme. So it also includes industrial schemes like factories that forms a body corporate, office parks that form a body corporate. So all of those basically, but if you're not 100% sure about your particular scheme, you're welcome to contact us. We will have a look with you at the definition again to see, but basically all community schemes must register with CSOS. They currently have a system that makes it easier for us called CSOS Connect. So what we as Trafalgar, as managing agents, have done is we've created profiles on the CSOS Connect site where we link all our schemes, where we register all our schemes, where we can manage, we can send through rules for approval, we can send through annual returns, all of those. But there's basically the link to the CSOS Connect site. So that's basically that in terms of registration. Then also what you just need to make sure for your scheme, there was an old CSOS registration number sequence that used to say CSOS./reg/a number/the province/a number. But going forward, CSOS is issuing new registration numbers. So what happens is when you link a scheme on CSOS Connect, then you are immediately issued that new registration number. And you can see there at the bottom of the slide, this is what the new registration number looks like. It contains the year/a number/a number. So it's shorter, easier to use, as because we use these as reference when we pay over CSOS levies, which we will talk about just now. But very important that every community scheme must register, must get a CSOS registration number as per the Act. Then in terms of the next item, CSOS rule approvals. So not going to read through all of this, but what it basically boils down to is that the Act says that rules only come into operation on the date of issuing of a CSOS certificate approving those rules. So we all know conduct rules, we need to pass a special resolution by the owners to approve. Management rules, we need to pass a unanimous resolution by the owners to approve. But the Act also goes further and say it must also be approved by CSOS, and it will only be enforceable once CSOS have issued that certificate of approval. So they could come back and ask questions, they could come back and say, please amend certain things, but in the end, they issue a certificate and they call it a Section 10 certificate that basically says that we have, as CSOS, approved your rules and they are now enforceable from that date of that certificate. So we also have escalation channels at CSOS as Trafalgar for different types of things, one of them being rule approvals. So if we see that we battle to get rules approved, we escalate this at CSOS until they're approved. And as Trafalgar management, we also meet with the chief ombud of CSOS quarterly to just touch base and see what we can we do better, how can we improve, what comments can we give them. So that is also just for your peace of mind. And then in terms of CSOS levies, so again, a lot of legislation on the screen, but what it boils down to is that the community scheme, who is now registered with CSOS, who now have rules approved by CSOS, must also collect CSOS levies and pay these over to CSOS on a regular basis. So what they've done is they've said that the levies CSOS levies are calculated only on the admin levy, not the reserve levy, not exclusive use contributions, nothing like those, just on the admin fund levy, and also not on special levies. And just an example on the screen, you will see that they have a formula where you calculate, which I will show just now, where you calculate your CSOS levy. that basically says the first 500 Rand of your levy is exempt from CSOS levies. So if your admin fund levy of your unit is 499 Rand, you are exempt from paying a CSOS levy. If your levy is 500 on the dot, exempt. If it's 501, now we have to start calculating CSOS levies, which I will show to you just now. It is also important that this is the monthly levy of the unit minus 500 Rand. So the first 500 Rand of the levy of the unit is exempt. Where you are the owner of more than one section, for instance, you own a flat, you own a garage, which is a section, you own a storeroom, that is a section. Each of these sections have their own separate admin fund levy. You can't add them together. Each of them have their own separate admin fund, and on that you calculate the CSOS levy. So there I've just given an example on how to calculate. So it's the monthly levy of the unit minus 500, because remember the first 500 Rand is exempt, times 2%, which then gives you an amount that is payable, and the cap on that is 40 Rand per unit per month. CSOS is investigating a process of making this a fixed fee across all units. Doesn't matter what your levy is, but that has not been announced yet. The talk around the town is that that fixed levy could probably be like 20 Rand per unit per month, but it hasn't been finalized, hasn't been fixed. But we will keep you up to date as soon as we get more news on that, because that will obviously make it much easier to calculate. Then you don't have to go and minus this and times that and percentages and all of that. So CSOS then also came out with their regulations to say that the CSOS levy must be paid over to CSOS on a quarterly basis. And I've given you the dates that they've given in their practice directives on how these quarters work. So basically after each quarter, what we as Trafalgar do is we pay over the full amount of CSOS levies collected on all our schemes to CSOS and get them to calculate and to allocate these levies to the specific schemes. We are currently also in a process of just a checkup, reconciliation of all the CSOS levy accounts, because CSOS also issues statements for these levy accounts. So it's important to check these statements, to check that they're correct, to check that all the payments have been reflected, and just to make sure that we're still on a par with them. So that is a project that we regularly do. Then the last part from my side is the CSOS annual return. Just shortly, that the access every community scheme, and we've looked at what a community scheme is, must submit an annual return. There's basically a prescribed form, and you attach the audited financial statements and any other prescribed documentation that they would need. And this can also be done on CSOS Connect. Very quick and easy to do, but we also do that for our clients on every year after the end of the financial year. So basically, that is another service that we provide. That is it from my side. I don't know if there's any questions so far on what I've been talking about.
Karine, I think there are provisions for pensioner discounts on CSOS levies, which might be a specialized topic as well, but I think there is that one concession just to make the point, and that can be clarified on request to our contact details afterwards.
Yes, absolutely.
Good. Thank you for that, Karine. That was useful. So, Brendan, over to you. Thank you.
Thanks, Andrew. That was nice and swift. Thanks, Karine. Appreciate that. And good evening to everyone present in the webinar. Right, let's start with the general dispute resolution process through CSOS. You can just move to the next slide, Karine. What I would like to do is just start with Section 39 of the CSOS Act by highlighting the importance thereof, because I think the success of any CSOS application really hinges on this section to a large extent. And what we've done is we've just included a snippet of the excerpt, Section 39. I know it's quite extensive. I don't expect anyone to read through this at this point, but it's really just to give you a feel for the section and the structure thereof. So what Section 39 really is in the CSOS Act is it's an area which contains an exhaustive list of all items of relief which you can claim through CSOS. And with emphasis on that word exhaustive, Just noting that if anything falls outside of this ambit under Section 39, it will highly likely be rejected by CSOS. So what we're looking at really is, as you can see in terms of the headings, it covers areas such as financial issues within schemes. If you move on past that, it deals with disputes around behavioral issues, scheme governance issues as well. Next slide, Corinne, it will move on to further areas of relief. If you have any concerns or disputes around, let's say, meetings held within a scheme or potentially the process followed around meetings, this falls within the section as well. Any concerns or disputes around management services, that's catered for under Section 39.5. Just quickly moving past that, any works on private areas, common property areas, if there's a concern around that, it can potentially be claimed for. And then it moves on really to speak to potentially a request for information, which either the scheme might hold or the managing agent might hold, which, let's say, an entity or a person might require in order to exercise their rights. So that's just a general feel for the section. We can move on past this, Corinne. All right, so as I've noted here, obviously way too much information to go through during a webinar setting. But again, I think it's important to just, take away from this that it is exhaustive. We do need to be very particular in the way that we structure the prayers for relief. We need to ensure that whatever item of relief you are claiming, that it does fall within this ambit. And if you do require a copy of the full CSOS Act, Corinne can also provide that post this session on email. Let's move on to the next slide, Corinne. Right, so how is this all applied? It really starts with a CSOS application. One must ensure that your prayers for relief are catered for, as I've said, under the Section 39 that I've referred to. And again, just remember that it is an exhaustive list of items. I come across many owners, for example, that they attempt to lodge an application directly with CSOS on their own, but they're not fully aware of the Section 39 and exactly what can be claimed for, which ultimately leads to their applications being dismissed. I'll go on to then say that should your prayer for relief fall outside of this ambit, again, it may very well be dismissed. It's a pitfall that we do need to focus on, and we need to avoid this at all costs. This is what we advise our clients on. Let's move on to the next slide, Corinne. Right, who may lodge a dispute? We can now refer to Section 38 of the CSOS Act. This section speaks to the fact that any person may lodge a CSOS application, provided that such person is a party to or is materially affected by a dispute within a community scheme. That phrasing is very important. I've just noted here that, interestingly, we dealt with a matter a couple of months ago, which basically involved a shared boundary wall between two neighboring community schemes. Trafalgar managed the one, and we had to approach CSOS in order to seek relief in terms of having repairs affected to that wall. Unfortunately, CSOS came back and actually noted that this doesn't fall within their purview. They stated further it falls outside of their mandate because they don't deal with matters between two neighboring schemes, but rather only disputes within a particular scheme. Okay, further to that, previously there was a fee of 50 Rand, which was applicable to CSOS applications, and 100 Rand applicable to adjudications. That has now been done away with. So this application process is completely free of charge. Nothing in terms of any payment will be requested from your side if you lodge an application. Trafalgar does attend to these CSOS applications and responses on behalf of our clients, along with external parties when requested to do so, and provided we receive our assigned mandate as well. Again, if you have any requests or queries around this, please feel free to engage with us further on this. Let's move on to the next slide, Corinne. Right, CSOS stages. I've just summarized the 3 stages which we need to deal with. Stage 1, conciliation. Stage 2, adjudication. And stage 3, appeal or enforcement. Let's drill down further into the details on the next slide. We'll start with conciliation. Right, in terms of conciliation, a party will lodge an application with CSOS in the prescribed form. So there is a particular prescribed application form which you can access. You'll see in brackets, I've just referenced the CSOS website if you would like to access it. If you log onto the website, you'll see right at the top section, there's a tab entitled Forms. If you click on that, it will open up a page which contains the actual the short form version of the application for dispute resolution. Alternatively, we would also be happy to engage with you further on this to assist with it. But CSOS will assess such application. They will refer same to the party or the parties cited therein as respondents, provided the contents thereof fall within its jurisdiction. In practice, the respondents are afforded 5 to 7 business days to respond to this. CSOS will thereafter relay any submissions received from the respondents to the applicant for review. The applicant is then afforded an opportunity to lodge a response only in respect of the issues raised in that submission. Anything outside of that, again, will not be considered by CSOS. The applicant must then also confirm whether the application is to proceed to conciliation or whether potentially some sort of resolution has been achieved at that point prior to conciliation. Once we progress to conciliation, the affected parties meet with a conciliator online via an MS Teams meeting, wherein the conciliator then attempts to achieve a resolution which is acceptable to both sides. Should a resolution not be achieved at this point, a certificate of non-resolution is then issued and the matter is referred to adjudication, the next stage. Should the parties achieve a resolution, however, then a settlement agreement is actually drafted in the conciliation setting. I've been involved in many of these where you physically see the drafting in front of you and you have an opportunity to either correct or maybe propose some amendment to the settlement agreement based on an agreement achieved amongst the parties. That agreement is then sent to both sides for signature, and if it is signed, the matter is considered closed. In respect of legal representation at these conciliation meetings, if it is requested by a party, it is only permitted if the conciliator and all the cited parties consent thereto, or if the conciliator deems this necessary after having considered factors such as the nature of the questions of law raised in the application, possibly the complexity of the matter, and the ability of a party to represent itself effectively. Let's move on to the next slide. Thanks, Corinne. Right, stage 2, adjudication. Matter must be referred to adjudication within 7 days post the issuing of that certificate of non-resolution that I referred to earlier. Notice of this movement to adjudication is then referred to all the affected parties for transparency. The appointed adjudicator will then assess the merits of the case, having sight of all previously submitted documentation, and will potentially request any final submissions from both sides. You then at that point have an opportunity to submit further submissions, maybe something that you might have forgotten about, or if something that you feel is relevant or pertinent to the case at hand that didn't form part of the original application may be then submitted in this fashion. However, it's a voluntary thing, so if you don't have anything further to submit, there's no requirement to do so. You can simply refer back to the original submissions. Thereafter, the adjudicator will either request that the cited parties attend the adjudication at CSOS's offices, or will hand down an order after having reviewed the case based solely on the submitted documentation, without any meeting having been held. In practice, as I say, I'm invited to many of these meetings. Generally, this is decided based solely on the paper submitted. I think in the past 6 months, I've only attended one in-person meeting at CSOS's offices in Pretoria, but that was really an exception to the rule based on the context of that matter. Finally, on average at present, we are seeing matters being resolved within 2 to 4 months post the lodgement of the initial application. This is dependent on the context though, but in general, that is the timeline that I see in terms of resolution. This is certainly a marked improvement on CSOS's historical performance. Let's move to the next slide, Corinne. Right, stage 3, appeal or enforcement. So upon receipt of an adjudication order, the affected party may elect to appeal same and would need to do this within 30 days post-delivery of the adjudication order, provided such appeal pertains to a question of law only. Now, that is very important. If there's a question around a matter of fact, for example, it will not be entertained. It must specifically be around a question of law raised. The appeal will then be heard by the High Court, dependent on jurisdiction, and a determination thereon made in such court. However, should no appeal be lodged, and in the instance where the party against whom the order was handed down does not abide by the terms thereof, the other party may seek an enforcement order through CSOS, which can be made in order of the High Court. The clerk of the High Court would register a copy of the CSOS order, and upon doing so, it becomes legally enforceable. If the affected party against whom the order was handed down still is in breach of this order, they run the risk of being in contempt of court, which is a very serious offence. And again, I mean, we can advise on this further, but in my experience, even before we get to the adjudication stage, generally, even if you're attending a conciliation and the matter is very clear, it does seem to entice some sort of, if we're talking about levy repayment of that debt, or if we're speaking about, let's say, some sort of structure erected on common property, it does induce this party into attending to whatever needs to be attended to as requested. I've noted here that we have assisted our represented clients with the above process on several occasions, and we are happy to do this to ensure that the order is enforced. Please feel free again to engage with us on this further if you need any assistance in this regard. Let's move on to the next. Right, now dealing with the restructuring of CSOS. CSOS has made a concerted effort to restructure its organization over the past few years with a view to improving efficiencies along with the quality of its overall service provided to schemes. We've seen this in practice, so this is not just lip service. I can attest to this. We also, as Corinne was alluding to, we meet with senior representatives at CSOS quarterly, sometimes more regularly than that, and this is something that has taken place. Senior personnel within CSOS have also noted that they are assigning matters to adjudicators, not just on a whim, but based on their particular area of expertise, which does lead to an improvement in the quality of orders being handed down, from what I can see. CSOS has focused on employing more adjudicators to assist with the volume of work that they receive on their side, along with there being a focus on employing more experienced and qualified personnel to improve the overall quality of output. As a result, we've seen swifter response times from CSOS over the past year, along with expedited resolutions to matters through the conciliation and adjudication stages, which has certainly been pleasing to us and our clients. Let's move on, Corinne. Right. The debt collection process through CSOS, which is certainly a hot topic at this point in time with many of our clients. I've just noted here that it is important just to remember that the levies within any community scheme, they are certainly a lifeblood of any scheme. I mean, without that, you cannot function effectively as a scheme. I've noted here it's crucial, the trustees and directors rely on this in order to settle all operational expenditure of a scheme on a monthly basis, and they certainly require this in order to also fulfill their fiduciary duties when it comes to maintaining all common property areas in line with an approved budget and or a 10-year maintenance plan. Going back to Section 39 of the CSOS Act, there are two grounds for relief in this particular respect. Firstly, Section 39(1)(e), and then secondly, Section 39(1)(f). And I've just included a snippet of those sections below. So Section 39(1)(e) speaks to the general repayment of any debt owing by an owner to the scheme, just a simple repayment of debt. Section 39(1)(f) speaks to the possible attachment of a tenant's rental, which would then be directed to a scheme with a view to settling any debt owing on a particular owner's levy account. So as you can see in the very last provision at the bottom of the screen, that repayment is directed directly to the scheme, and then we simply issue credits on the respective owner's levy account to offset it. Let's move on past this. Right, just continuing on the subject, we have focused on an initiative whereby we have advised our clients to refer more arrears matters to CSOS where appropriate, as opposed to law firms for collection. And the reason for this, there are two reasons mainly for this. The CSOS route is more effective in terms of cost, and secondly, the waiting period through CSOS is significantly shorter than that of the courts. From our perspective, we've lodged over 50 applications, debt collection applications specifically, since October 2024, and we have seen favorable adjudication orders being handed down in this respect in terms of the full settlement of levy arrears. I've noted as well, it's worth noting that our team at Trafalgar has fostered very strong working relationships with several senior personnel at CSOS, which aids in the follow-up process when seeking updates on lodged matters. We have seen the benefits hereof through swifter CSOS response times, which leads to expedited resolutions and a happy client at the end of the day. When representing our clients, we do, when I say pray, it's just a term we use in our applications, but ultimately we request full repayment of all outstanding debt owing on a particular owner's levy account. So this includes not only the capital levy amount outstanding, but also potentially interest that is raised, debt collection fees, and taxed legal fees appearing on an owner's levy account. Please do note that in order to successfully claim the above-mentioned arrears, the scheme requires, just to name a few, a signed levy resolution, a signed interest resolution, and confirmation of a debt collector certificate if a managing agent is operating in that capacity as well. Very important to note when actually attaching the relevant annexures for a CSOS application. Let's move past this, Corinne, thanks. Right, and then finally, just some exciting news from our side. We have recently launched an in-house legal advisory service for our clients and external parties. The name of this initiative is called the Community Catalyst, as you can see on the slide. And ultimately, the aim of this is to provide expedited solutions to problems within the property sphere. And if I just think about, everything I've had to deal with over the past few years as a portfolio manager as well, I've seen a growing number of very intricate and complex matters which are being referred our way. I'm not sure if it's because owners and schemes are maybe paying more attention and are more interested in, let's say, the applicable legislation these days and let's say case law precedent, but there certainly has been an increased volume of very intricate legal related queries within the property realm being referred to us. So it's an exciting initiative. I've just included a very summarized costing model on the right-hand side of the slide, as you can see. It comprises 3 tiers just based on the nature of the work that we can assist with. So just very quickly, tier 1, it basically refers to what we've already spoken to, just general CSOS applications, responses, attendance at conciliations, and also final submissions at adjudication stage. We can assist with that at a cost of 750 Rand ex VAT per action. And it also includes the debt collection process that I've spoken to through CSOS at the same cost. If you have a look at tier 2, it covers areas such as guidance on all applicable property law legislation, assistance with MOR and conduct rule related queries, which we've seen a lot of recently, contract reviews and advisement, assistance with internal dispute resolution processes within a community scheme, guidance on the structure and conducting of general meetings as well, which I am seeing more and more of recently because trustees are paying more attention to, let's say, the overall structure of a general meeting or a special general meeting, just to ensure that, everything is catered for from a compliance perspective in terms of the legislation. The cost for that, as you can see, is 1250 ex VAT per hour or part thereof. And then just very quickly, finally, under tier 3, you can see that we can assist with matters such as the drafting of conduct rules or amendments thereto, ensuring compliance with the applicable legislation, case law precedent assessment as it pertains to a scheme, and then the overall drafting of legal opinions on a wide array of legal matters, which I have attended to quite a bit recently as well, and you can see the cost for that. So interesting work being referred our way. I appreciate all of that. If you look at the far left-hand side of the screen at the bottom, I've just summarized some of the matters that have been referred to us over the past few months, not only by our clients, but also external parties. It's matters such as contractual reviews, drafting of agreements tailored to an estate. So, for example, we were requested to draft a water tank agreement for a scheme recently in our Johannesburg portfolio. And this agreement covered areas such as indemnity on behalf of the trustees, liability aspects, insurance coverage and aspects, also the applicable clauses relevant to additions to common property, which need to be catered for as well, along with the relevant resolutions which would need to be passed. So it was a full agreement drafted, which the trustees are then using to send to owners who would like to install water tanks, just to ensure that all relevant processes are followed to the T. Further to that, letters of demand around PI requests, that simply just refers to the Promotion of Access to Information Act, revision and updating of MORs and conduct rules, and then finally papaya-related advisement, which has also been quite significant in terms of the volume coming our way. I think most individuals in schemes are very interested in papaya-related queries and requests. So yes, I think that brings us to the end of this slide, Corinne. Just like to say, I'd be very happy to take any questions at this point. But again, if you have any queries or any related requests, please do feel free to reach out to us. I would be happy to engage with you further on this. Thanks,
Brendan,
Andrew.
thank you. So to get into questions, Brendan, and we've been answering in the background as well, but maybe just to talk about arrear levy collection first. I'd say that as a managing agent as well, we are extremely interested to be, pushing arrear levy collections through CSOS in terms of achieving binding orders rather than the traditional legal collections route, because it's most certainly faster. As much as CSOS has had problems and matters have either gone missing or been slow or have needed sort of, chasing, it's still faster than the courts with the court backlogs, etc., and dramatically cheaper. So, Brendan, I mean, would you comment on the prospects of CSOS becoming an increasingly important channel for collecting arrear levies, and the sort of practicalities of it being faster and cheaper than going through the courts?
No, I certainly agree with the comments. Again, I mean, we've seen it in practice, Andrew, where it certainly is quicker. When you lodge an application at CSOS, if we assist you with this entire process, it is significantly more cost effective, but also simpler in terms of having to go through a law firm, for example. I mean, at times, if you consider the consultation fees through law firms, the lengthy process that you have to follow through courts, I've seen matters through the courts that are taking upwards of 1.5 to 3 years to reach resolution. Whereas, as I said earlier, over the last few months, I'm seeing matters being resolved within 2 to 4 months, depending on the context of the CSOS matter. So it certainly makes sense because, quite frankly, as I said, it's an absolutely free process to follow. So I don't think there's anything to lose in that regard. And the quality of the orders, again, that I'm seeing being handed down by CSOS are significantly better than what we were used to, let's say, several years ago. It certainly has been a value add for our clients. More and more of our clients are utilizing the CSOS process with much success. I really can't see a downside to the process.
Yeah, I mean, it's certainly worth a try. And, I think the other key point to raise is that legal fees are extremely expensive for collections matters, and that only tends to exacerbate the issue of the arrear levies and compound those, for the owner to settle. So it's a double-edged sword in terms of going down that route as well. So definitely something to think about. I can attest as well, and maybe Brendan, you can just comment too, but, I think CSOS has made a concerted effort, probably quite recently in the last 6 months, I'd say, to number one, improve their digital channels. Karine talked about CSOS Connect and doing more of their administration electronically online, which certainly helps their administration. And they've got a document management system behind that. And secondly, they are working hard to increase their capacity of adjudicators. And they typically use retained attorneys, private attorneys with experience to augment their capacity in their different regional offices. So they've been able to achieve the acceleration of performance, of turnaround times, of professionalism, let's say, through that way where they are contracting the private sector particularly to do that. And, we definitely are seeing the results of that. Now, based on a number of questions we've seen tonight, that doesn't mean that every single case goes smoothly, goes well. Quite a few of the attendees tonight have had matters lost or, delayed well over a year. Perhaps some of those are historic, before the last 6 months where we've seen a significant improvement in CSOS, but most certainly we are able to assist to chase matters, to escalate matters, to follow up matters with the reference number. So, Brendan, do you want to just comment on that? Are you seeing private adjudicators in the main, and therefore that's the reason that we are seeing, a quick increase in capacity and therefore, more relevant expertise and experience being applied to these matters in that way?
I am. I mean, for example, I've sat in conciliations and adjudications where, it's been spoken about in terms of the experience of the adjudicator or conciliator. For example, we see matters being referred to, highly experienced property lawyers with many years of experience in the industry. When it comes to debt collection, I generally find that it's referred to a conciliator or an adjudicator, which has some sort of financial background as well, or some sort of BCom law background. So there certainly is an understanding of how, finances work within a scheme, and that is leading to more, an improved quality, let's say, in the overall orders and more refined orders in terms of the insight being provided. So yes, I mean, as I was saying in one of the slides, Andrew, there is certainly a concerted effort to disseminate applications to the relevant conciliators that are experienced in those areas. I think years ago at CSOS, it was just a case where a matter would come in and it would be disseminated to a conciliator with the most capacity. That has been done away with. That's no longer the process being followed. And I certainly see that in these discussions being held at conciliation stage.
Great, Brendan. Brendan, can you talk a little bit about, let's just take an owner in a scheme that has a dispute, and, what would you advise them in terms of collecting evidence, collecting documentation, assembling their file of evidence that they are going to use to lodge a dispute so that they promote the best possible outcome in their interests? Because it's not obvious, what they should collect, what they are going to submit, how they make sure that their case and facts is correctly and accurately presented.
Sure. I mean, again, I think an owner needs to be very strategic when compiling the application, and particularly the annexures to that application. So, for example, an owner might be lodging a dispute. The context of the dispute might be, let's say, some illegal structure placed on common property. You might then have to take photographic evidence of that and attach it as an annexure. You might have to potentially collect eyewitness accounts of what has taken place. So ultimately, it comes down to the context of the matter. And Andrew, something an owner also needs to be very cognizant of is the fact that it doesn't breach papaya regulations, which we've spoken about as well. So you need to be very careful in terms of what you attach, in terms of the information that you attach. The manner in which you procure that information is relevant, is important to ensure that there's no breach from a papaya perspective. So yes, I mean, it can become intricate. It's certainly something that needs to be focused on, particularly the annexures, because it strengthens one's case. When I see, applications being lodged, Andrew, directly by a client to CSOS, I don't generally see the correct annexures being attached to that, which speaks to the actual substance of a case. It seems to just be whatever an owner can, get their hands on is just simply attached to the application. And most of it is disregarded by the conciliators because it's not relevant. So yes, it is something that is quite strategic, and we need to be very particular in the information we attach to strengthen one's case.
Yeah, and I think that's the sort of takeaway from tonight is, that owners or trustees and directors that are involved in disputes, give serious thought to, compiling a portfolio of evidence, making sure it's clear, it's factual, it sort of stands on its own, because typically it's going to be a written submission, which will be evaluated offline by an adjudicator. And, it needs to speak to the dispute and, make it easy for the adjudicator to rule in favor of the applicant. Just another comment as well is that, as managing agents, we see disputes, ping-ponging backwards and forwards in terms of emails and, escalating anxiety and aggravation and negativity for very long, and I'd like to sort of, make the point that calling a dispute out, decisively and early is very helpful, because, it actually short circuits, ongoing wasted time, ongoing wasted energy and effort, and it moves that matter into a forum where it can be independently, evaluated, adjudicated, and ultimately a binding order can be provided. So, I think that saves time in the end. It is very helpful that there is now a legislated channel that can actually adjudicate it in that way on those terms, and it actually does get to a solution or an answer in a reasonable amount of time. And the chief ombudsman has told us personally that, a maximum of 90 days is their target, which they are trying to achieve. They are measuring turnaround times. They are adding capacity to be working towards those turnaround times. There was a backlog. There has been poor performance in the past, but, the trend is upwards. And ideally, that is positive in terms of the industry. And ultimately, that's what CSOS levies are paying for, that particular service, and it's worthwhile then using it where it is required. Brendan, the common complaints as we hear are pets, parking, washing, and noise disturbances, maybe smoking as well. Some of those are quite difficult to record and document. Let's take after hours disturbances, noise, which kind of is typically after hours when there are not many people around. Evidence and witnesses there is difficult to achieve and validate. What would your advice be in terms of, recording the relevant, let's call it evidence, to be able to substantiate a CSOS dispute?
Yeah, thanks, Andrew. So firstly, I mean, depending on the context, I would say start by consulting with your relevant agent, your managing agent. I think it's key to, again, just ensure that whatever evidence you are recording is not in breach of any particular provision of the Papaya Act. Because if it is, obviously that will be thrown out and the application could very well be dismissed. So again, depending on context, please do reach out to your relevant agent for further advice on this. And just be cognizant of the fact that, one may not necessarily take a recording of minors. I've had a situation in the past, Andrew, where a video was taken of children. They were under 12 at the time on common property, and that just inflamed the entire situation at CSOS. It was not permitted. It was seen as highly unethical as well, apart from any legislative implications. So, yeah, I mean, the answer, there's no clear-cut answer because I don't have the relevant context. But again, I think it starts with a very clear consultation with your agents so that you can receive the necessary guidance on this.
Yeah. And somebody like you is available, Brendan, for input and as you say, guidance to take it forward.
But Andrew, I wanted to echo your original sentiment, sorry, where you said that, basically, from my perspective, I really think a matter should not be allowed to fester. If there's a problem within a scheme, if there's some sort of dispute, and it's been dragging on and it's been prolonged for months on end, please try and avoid that at all costs. It really doesn't help any of the parties at play. Again, the key takeaway for me is don't allow it to fester. Try and be proactive. Try and preempt a problem becoming maybe a convoluted problem down the line through the elapse of time. Try and attend to it as swiftly and proactively as possible at that given point in time when it does arise or when appropriate.
Okay. Brendan, will you also confirm, I've seen a few cases where, difficult parties, let's call it that, where they see a CSOS dispute has been lodged, it gives credibility to the matter being escalated. We see many people opt in at that stage because they can see that, trouble's coming or that a binding order is coming, and or, as it escalates, they can see that they are going to be held accountable for certain actions. So, even before an adjudication order is achieved, we see positive results with people saying, oh, well, they better just sort of opt in, or they better concede, or they better pay up their rear levies, whatever the case might be, because it now creates, that impression of a resolution arriving.
It certainly does. I've seen that particularly in the debt collection setting at conciliation stage. So often, even before we arrive at conciliation, it does just the process that has to be followed seems to induce some sort of remedial action from the defaulting owner. So, for example, I can, off the top of my head, think of 4 instances where full repayment of the debt in our Pretoria office was actually affected prior to a conciliation stage. At conciliation stage as well, I found that most of the respondents, they almost want to settle immediately at that point because they don't wish to actually follow this process to the end through the adjudication stage as well. So again, that also induces some sort of remedial action, and at that point we see a settlement agreement being entered into on average, which is pleasing.
Yeah.
And I don't think a matter always necessarily needs to proceed to adjudication. It can actually be quite successful at conciliation, based on what I've just said.
And they all go through conciliation regardless. There's no sort of jumping or leapfrogging straight to adjudication.
It is the exception to the rule, Andrew. I've had a few instances where matters are referred directly to adjudication just based on the merits of the case and based on the discretion which CSOS uses. But I mean, it's probably less than 1% of cases. Most of these cases start at conciliation to afford both of the parties an opportunity to try and reconcile or at least achieve some sort of agreement, some sort of meeting of minds, which is the ultimate aim.
Yeah. And Brendan, CSOS won't entertain cases which are already in a court forum. Is that correct?
That is correct. If something is already at the High Court, for example, if you try and proceed through the CSOS route, it will be thrown out. CSOS, if CSOS comes across the fact that something is with an attorney in the High Court, in order to proceed further through CSOS, it would need written confirmation of the fact that that has been withdrawn. Either the matter has been withdrawn, or if it's before the High Court stage, that the mandate with the appointed attorney has been withdrawn before it would entertain that matter. So you can't run matters parallel through the courts and through CSOS. That's not permitted whatsoever.
Yeah, great. Brendan, there was an interesting question here. Can you just talk to the timeline and the process? Let's take the scenario of arrear levies. It's been through the CSOS process and adjudication. There's been a binding order in favor of the community scheme, whether it's a sectional title scheme, homeowners, doesn't matter. So now there's an order for the defaulting owner to pay their levies. Now the owner doesn't pay their levies, and the community scheme now needs to make that order a order of court to enforce. What happens thereafter in terms of ultimately getting to attachment of movable goods and ultimately attachment of immovable goods?
No, well, again, the positive thing through that is once you have the enforcement order, which is then stamped by the clerk of the High Court, for example, it becomes fully enforceable as if it was an order of the High Court. The positive thing about that, Andrew, is that it really expedites the process as a last resort scenario. So what I mean by that is, again, if you proceed through debt collection processes through CSOS, on average, it is significantly swifter than through the court process. Okay, so let's say you lodge an application this month, the matter reaches the adjudication stage and the order stage in the next 2 months, and that order is sent to the High Court for stamping to be made an order of the High Court. That will expedite the fact that we can then apply for a writ of execution to, first of all, try and sell the movable property of the defaulting owner and use the proceeds to settle the debt. If that is unsuccessful, through another BOLA return, we then apply for the Rule 46 to attach the actual immovable property to sell that unit at auction and use the proceeds to settle the debt. So from that stage, from that order being stamped at the High Court, on average at this point in time, it's tough to provide certainty on this, but I'm seeing timelines of approximately 3 months to reach that point in terms of selling, using the proceeds to settle the debt, and then starting with a clean slate through the clearance process, the levy clearance process.
Great. Brendan, how often do you come across matters where vague conduct rules are a complicating factor or lead to an unfavorable order? So meaning that, the importance of customized, accurate, effective conduct rules to achieve the right conduct and the correct compliance from owners in a community scheme.
Andrew, almost on a weekly basis, to be honest with you. Most of the conduct rules that estates have in place are outdated. We are receiving, because of that, more and more requests to revise conduct rules, make sure that it is in line with the actual prescribed conduct rules. It's one of the annexes to the Sectional Title Schemes Management Act. So yes, I see it almost weekly. It's a case where either the rules have been drafted too hastily and they don't cater for all eventualities, or they somehow fall short of something within the prescribed conduct rules, which is concerning. And it does need to align with those prescribed conduct rules, and it cannot breach any area of those prescribed conduct rules. So it is also a hot topic. Many clients are referring their conduct rules and their MORs to us to revise it, to advise them on any particular clauses that maybe are in breach of those prescribed conduct rules, and we are assisting with that successfully. But to your point, Andrew, again, if your rules are drafted, with particularity, with some thought, with full assurance that it is in full compliance with the legislation, then when you use those rules as supporting documentation through the CSOS process, it's highly unlikely that your strength of your case would be weak.
Yeah.
You should generally succeed based on very clear wording in the conduct rules, if you are claiming something which hinges on a conduct rule provision.
Yeah, absolutely. Brendan, I see as a managing agent, time and again that, it's a specific expectation and responsibility of trustees and directors to enforce the conduct rules. And it becomes a challenge where the trustees and directors ignore that responsibility, or they're not aware of that responsibility. And that can certainly cause issues to fester and escalate and become almost commonplace across a community scheme. So, would you just comment on the importance of that role being played by the trustees and the directors? Because there is really no one else that can take the decisions to enforce the conduct rules, on a decisive basis. Yes, one owner can hold another accountable on the basis of the conduct rules, but if the trustees and directors step in early, step in decisively, act consistently, it does actually create a common understanding and an environment where the conduct rules are respected, they are applied, it does become standard practice, and it leads to a more orderly, type of living environment, which is ultimately what owners want and what trustees also want to achieve, but it's a key part of their role. So do you see this in terms of the cases you come across and, where trustees and directors haven't sort of stepped up and fulfilled that role effectively? And what has it meant in terms of the actual process to get a dispute resolved? I'm thinking of the duration of it, overall and before it gets to CSOS in the first place.
Yes, sure. Thanks, Andrew. I mean, there are times where it's quite concerning because it's my experience that not all directors or trustees within a scheme are fully aware of all of their provisions in the MOR or the conduct rules, depending on what scheme it is. So how can you effectively enforce something when you're actually not aware of all of the provisions in that documentation? What we try and do is, I'm just speaking as a portfolio manager as well, if a dispute arises within a scheme and it's referred to us, either via the trustees or an owner or both, the first thing we do is obviously refer back to the primary governing document, which would either be the conduct rules or the MOR. We would then review that, pinpoint the relevant provision which might speak to that matter and speak to a resolution, and we highlight that to our trustees and basically respectfully request that they try and enforce that through the correct channels and as per that provision. So that's one. But yes, it is a problem because I think it's also a slight issue at every AGM when new trustees come on board or new directors, because again, I'm not sure, that all of them go through the process of perusing the MOR and the conduct rules at length. I think it's something that we should pay attention to and pay closer attention to and direct some focus to, because it also comes down to the managing agent advising a client correctly on the relevant provision in the conduct rules and MOR.
Yeah.
Without that, it's a case where I don't think the trustees or the directors can effectively manage a complex in line with their fiduciary duties. And again, I think what you're referring to, Andrew, also goes back to your overall fiduciary duties. Most of your fiduciary duties would be, let's say, referenced in conduct rules or the MOR, and it needs to be perused very closely to ensure that you attend to those duties.
Yeah.
The
And it's for
last
that
thing
reason that we've tried to put a very informative training website together. So, we have a sectional titled Trustee Training Course. We have an HOA introductory course for new trustees and directors, or for anyone to inform themselves of the roles and responsibilities of that particular role. We also have all the applicable legislation in Word so that, keywords can be searched and relevant clauses can be quickly found without having to read, long legislation and find it difficult to find, key clauses. Brendan, we're running out of time, but I thought I'd just ask you a last question. So CSOS does require internal remedies to be exhausted in terms of a dispute before it's lodged. So what does that mean? What is required to exhaust internal remedies? And, on what basis might CSOS dismiss a matter if they feel internal remedies weren't pursued thoroughly?
Right. So generally, if you're looking at a set of conduct rules or an MOR, for example, there should be a clause around internal remedies in terms of dispute resolution. I see it often in MORs where it refers to potentially an arbitrator being appointed by the parties and trying to resolve the process through that mechanism. But again, there may be an important and relevant provision in a set of conduct rules which speaks to the process that the trustees need to follow to try and engage with an owner or try and engage with owners to settle a dispute. If that fails, then as a last resort, you can potentially approach CSOS. There are times, Andrew, where CSOS specifically refers to that clause. They do look at this in the set of conduct rules in an MOR. I can't recall offhand if anything has been dismissed based purely on the fact that, let's say, a clause around dispute resolution, internal dispute resolution, hasn't been adhered to, but it does leave the door open for that possibility. I think we should try and avoid that at all costs. And again, it comes down to very clear advisement to our clients and external parties, because the first thing you should refer to is the process you need to follow to settle a particular dispute within a scheme and how to go about doing that. But also, you need to fully understand what it actually means when they refer to internal dispute resolution mechanisms. Often I come across trustees that either misinterpret that internal dispute resolution clause or just completely misunderstand what it actually means in terms of trying to settle amongst the parties.
Yeah. Good, Brennan. Well, thank you. So our time is up. My last comment will just be, the importance of communication. And obviously, CSOS is an escalation channel. It's best avoided if things can be resolved internally. And I find that just good common human interaction and communication goes a long way if the parties can be persuaded to sit around a table in a facilitated discussion, potentially with the trustees and the directors involved, just to compare notes, share information, discuss potential solutions, etc., and just get together. But, emails backwards and forwards and heated discussions offline, don't really get to the crux of the matter of good, solid communication, with the mutual objective of resolving a dispute amicably, quickly, and in a personable way, between neighbors and people that live in the same community scheme. So our contact details are on screen. I don't know that we've managed to answer all the questions that have come through tonight, Karine. So the offer's there to email any of us if there are outstanding questions. A reminder that the recording link, the slides, will be emailed to all those that have registered tomorrow. Thanks very much for your attendance. We appreciate your time. Thank you to Karine and Brendan for contributing this evening. If you have time for the survey, we would appreciate that. And then we look forward to you joining our next month's webinar, and we will send the invitation 2 weeks in advance. And we try to bring up topics that will be relevant and be useful. And I think the next